soon as I can get the slide to move.
Thank you, Janice. My name is Nancy Breiden. I'm the director of the Disability Law Project, which is part of Vermont Legal Aid. And I'm going to be presenting today along with Jackie Rogers, who's the director of the Office of Public Guardian, which is housed within the Department of Disabilities, Aging and Independent Living in Vermont. I just want to give a couple quick disclaimers. Many of the statutes and laws we'll be talking about today are Vermont-based laws, and I understand there are people participating in this webinar who are participating from other states. So just a heads up that the laws we're going to be talking about are Vermont-specific laws. The other disclaimer is that we're not going to be talking about minor guardianships at all today. Those come under a completely different statutory scheme. So we're only going to be talking about adult guardianships today. I'm going to turn it over to Jackie now.
Hi, everybody. We're going to start off talking about what is guardianship. Guardianship is a legal status of a person over 18 in Vermont, and the emphasis is on a cognitive impairment that affects decision making. A lot of times people will describe to me that someone needs a guardian because they don't have self-care skills, but really guardianship is directly related to decision making, not someone's physical ability to do things. In Vermont, guardianship can be ordered by two different courts, the probate court or the family court, after an evaluation is done. There's a whole process that Nancy will be talking about in a little while that has to be followed, and then the court makes a decision. Each guardianship has a specific order for which powers are being given to the guardian. There are 6 general powers, or 6 overall powers. General supervision is a large category that includes where somebody works or gets services, the services they get, also school decisions, medical and dental care, handling somebody's financial or money needs, contracts, and these can range from small things like cell phone contracts to large things like purchasing homes or selling homes, property, and making sure that folks have legal assistance when they need it. Vermont's guardianship laws are quite progressive, and both of them require that guardians make their decisions in the least restrictive manner possible with maximum input from the person. And that means that guardians need to listen to what people say they want and try as much as is practical to honor those wishes. Now here's what guardianship isn't. These are the little known facts. Folks tend to think of guardianship as all powerful, all those 6 powers, but there are a couple powers missing. And the first one is magic. There's no magic power in guardianship. There's no ability to just make everything right immediately all the time. And there's also no force. And that's another fact that is surprising to people, that guardianship does not come actually with significant teeth. And people cannot be forced to follow a decision the guardian makes if they choose to make their own decision and then have the ability to act on it. So that means that if someone doesn't want to take their medications and there isn't a way to support them to do that, there's no force involved in guardianship to make people take their medications involuntarily. Guardians cannot consent to involuntary medication, nor do they have the authority to consent to involuntary hospitalizations against people's wills. Also, in terms of placements, guardians can check out all the placements available for people and bring them to the placements and make a decision with the person. And then if the person makes a whole different choice and either refuses to move to the placement that was chosen or leaves the placement that was chosen, there isn't any way to actually force them to stay in that placement. So that often comes as a shock to people.
This is Nancy again. I'm going to talk a little bit about the kind of restrictions that are involved in guardianship, and then talk about the process for having a guardian appointed. And I just want to say that, we were asked to talk about alternatives to guardianship, but also people wanted to have a kind of a nuts and bolts of how guardianship works, how the process works. So this part's going to be a little bit dry, and I'll try not to get too much in the weeds. And I think what people really want to be hearing about is what the alternatives are, but we should slog through this. So just bear with me as we get through it. So first of all, it's really important to understand that guardianship is a significant restriction of individual rights. It takes away the right of an individual to make decisions about important areas of one's life. And if people think about the number of decisions that you make each day and what it would feel like to have the ability to make those decisions taken away from you, you can begin to conceptualize what the real impact of guardianship is. Guardianship can be stigmatizing. We certainly hear about people, particularly younger people, who among their peers feel that there's a stigmatizing factor if they let it be known that they have a guardian. Once imposed guardianship can be difficult to get out of. Once under a guardianship, there's an assumption that the person clearly, there wouldn't have been a guardianship order if the person hadn't been incapable of taking care of themselves. Therefore, there's this burden to show that now you are capable of taking care of yourself. So that can be difficult. Guardianship should only be considered after all less restrictive alternatives have been considered. And as Jackie mentioned, our guardianship statutes are pretty progressive when compared to other statutes nationally. Our probate court guardianship petition, so if you go to probate court and you're going to file a petition for guardianship, you have to describe all alternatives to guardianship that have been considered and provide an explanation as to why each alternative is unavailable or unsuitable. So if you've gone through that process and there are no less restrictive alternatives, think about which decisions the person really needs help with and only ask for guardianship power in those areas. Another way to consider least restrictive alternatives is to consider a voluntary as opposed to an involuntary guardianship. And the most significant difference between a voluntary and involuntary guardianship is a person under guardianship in a voluntary guardianship can end the guardianship just by writing to the court and asking that the guardianship be terminated. If the guardian, the acting guardian, objects to the termination, then the court will treat the case as an involuntary guardianship proceeding and just go through that process.
Sure. This is Jackie, just adding one more option. We've been seeing more and more time-limited guardianships being ordered. And so a young person will come into guardianship. They're not quite ready to make decisions yet. And everyone agrees to work on those alternatives that we're going to talk about. And right in the guardianship order, the judge will put in that the guardianship can sundown on a specific date or be re-examined in court in 3 years or 5 years.
So in this slide, we list a lot of reasons why guardianship should be kind of the last resort. But I do want to say that there clearly are cases where guardianship is needed, and we're not advocating that guardianship be done away with entirely. We need to start thinking differently about guardianship rather than getting rid of it entirely, or at least that's the perspective we're coming from. So now we're going to start through the guardianship process, and I'm going to be talking about two different guardianship laws. There's a public guardianship and a private guardianship, and it gets very complicated. And so through the next series of slides, I'm going to try to just highlight the differences between the two. I should say that probably most of the people that are participating in this webinar are going to be more interested in the private guardianship than rather than public guardianship. But it's important to know that the two guardianships exist. So under a public guardianship, the Office of Public Guardian is appointed to act as the guardian. Under a private guardianship, a private individual is appointed to act as guardian. Next slide. So I said there's two different kinds of guardianship. There are two different adult guardianship laws. Title 18 of the Vermont statutes governs the public guardianship law for people with an intellectual disability who are over the age of 18. So only for an adult with developmental disability can a public guardianship be ordered. Is that right? Yeah.
Under Title 18.
Under Title 18. Title 14 guardianship has both a public and a private guardianship. So the probate court under Title 14 can appoint a guardian, a private guardian for an adult with any kind of an impairment. The Title 14 guardianship can only be ordered for public guardianship can only be ordered for people over the age of 60.
Who don't have a developmental disability.
What? Yeah. So the two statutes have two different definitions of who a person in need of guardianship is. So for Title 18, the definition is an adult with developmental disability who's unable to make decisions in major areas of their life and is not receiving the active assistance of a responsible adult. And I'll note that last qualification, not receiving the active assistance of a responsible adult, is one of the ways that guardianship is avoided. If there is an active adult who's responsible, then public guardianship under Title 18 is not going to be available. Under Title 14, the definition of a person who's in need of guardianship is an adult with a cognitive impairment of any sort. So in Title 18, the individual has to have a developmental disability. Under Title 14, the impairment can be any sort, whether it's mental health or age impairment or any other kind of cognitive impairment. And then further, the definition is that the person is unable to meet their need for medical care, nutrition, clothing, shelter, hygiene, or safety, so that illness or disease has occurred or is likely to occur, or there's recent behavior showing gross mismanagement of income and resources leading to financial vulnerability. So there's two different courts for the two different kinds of adult guardianships proceedings. Family court handles Title 18 guardianships. And again, that's only public guardianships for people over the age of 18 with a developmental disability. And the family court can only appoint a public guardian. The family court does not have the authority to appoint a private person to serve as guardian. And the probate court governs Title 14 guardianships. Again, those are for people of any age where the appointment of a private guardian is requested. The court can only appoint a public guardian. Probate court, again, can only appoint a public guardian for people over age 60. Except there's one other circumstance when the probate court can appoint a public guardian for somebody who's under age 60. And that's where a petition's been filed for an adult with a developmental disability, and they've named a proposed private guardian. And the court determines first that there is a need for guardian, and second, that the proposed private guardian is not suitable. Therefore, the court will say, well, the person needs a guardian, but the proposed private guardian is not appropriate. So I'm going to appoint the Office of Public Guardian. And so that's the limited circumstance where the probate court can appoint a public guardian for somebody under the age of 60. Once that appointment is made, then the Office of Public Guardian is required to go over to the family court and start that process so that the family court can officially appoint the public guardian. So having gone through all that, what's the bottom line? So if you're seeking appointment of a private guardian for an adult, the petition should be filed in the probate court. If you're seeking appointment of a public guardian for an adult with a developmental disability, file the petition in family court. If you're seeking appointment of a public guardian for an adult over the age of 60, file the petition in probate court. And then one note about the difference between, a pretty big difference in the guardianship proceedings in family and probate court. So in the family court proceeding, technically only the state's attorney can file the guardianship petition. So what happens is somebody who wants to file a petition for public guardian goes to the family court, and that person fills out the form at the family court, and the clerk at the court sends it along to the state's attorney for filing. So the state's attorney files it, and once the petition is filed, the state's attorney is responsible for pursuing the petition. So basically, the person who filed it really doesn't have that much to do with the case once it's filed. And the petition has to be filed in the county where the person who is the subject of the guardianship petition lives. So again, the processes are going to be essentially the same, whether you're in family court or probate court. Again, the only real difference is that in the family court, the state's attorney appears in court and pursues the petition. In probate court, the individual who filed the petition appears in court and pursues the petition. And usually a petitioner in probate court is not represented by an attorney. They can be, but for the most part, they are not. The guardianship powers in the two different guardianships are the same pretty much, except that there is no financial power for the guardian in a Title 18 public guardianship. In both family and probate courts, the person who is the subject of the guardianship petition is called the respondent. So what happens after the guardianship petition is filed? And this is going to be the same in both courts, except where I've noted this. The court will order an evaluation for the respondent to determine the need for guardianship, and this evaluation is usually arranged for through the Office of Public Guardian. The court will set a date for hearing on the petition. Some courts set that date right when the petition's filed. Some courts wait till after the evaluation comes in. There's different practices in different courts. So the court sets a date for the hearing. And then in a probate court proceeding, the court will order a background check of the proposed guardian. And that it usually happens after the evaluation is done, because they first want to make sure that the evaluation is going to recommend guardianship before they go through the process of a background evaluation of the proposed guardian. The court will appoint an attorney to represent the respondent. In family court proceedings, the Disability Law Project is always appointed to represent the respondent. In probate court proceedings, the courts usually appoint an attorney from the private bar. In some more complex cases, the court may appoint the Disability Law Project. But the important thing is that the person who is the subject of the guardianship petition will always have an attorney. And again, the petitioner, at least in family court cases, will usually not have an attorney. So the attorney who is appointed to represent the respondent meets with the respondent to determine how the respondent wants to respond to the petition. That attorney should follow the direction of the client. And that's the attorney's ethical responsibility. No matter how kind of far-fetched what the direction of the client might be, it's the attorney's responsibility to vigorously pursue that position on behalf of his or her client. So if the attorney meets with the client and feels that the client isn't able to understand the nature of the guardianship proceeding or give direction to the attorney should ask the court to appoint a guardian ad litem. So a guardian ad litem is a person who is appointed by the court to stand in the shoes of the client and give direction to the attorney according to how he or she believes the respondent, the client, would give direction. And this seems a little outrageous because here's this person who doesn't know the individual at all, who's being asked to make decisions on their behalf about how the case should proceed. But that's the kind of somewhat faulty system that we have set up to give direction for attorneys, because attorneys have to take direction from the client. It is not the attorney's job to advocate for what they think would be in the best interests of the client or what other people think would be in the best interests of the client. The attorney has to have a client giving direction, and if the client's not able to give direction, then we have to have a guardian ad litem to give the attorney direction. The guardian ad litem doesn't have any of the guardianship powers that Jackie referred to earlier. The guardian ad litem's only role is to give direction to the attorney in the particular case for which they've been appointed, and the guardian ad litem's role ceases to exist at the end of the guardianship proceeding. So we finally get to the hearing. Once the evaluation is completed, the court will hold a hearing. At the hearing, the person who filed the petition for guardianship must prove to the court that the guardianship is necessary. And again, in family court, that'll be the state's attorney, and in probate court, it will be the person filing the petition. The kind of evidence that the court will look at is they'll pay a lot of attention to the guardianship evaluation. The court will also look at kind of the behavior that has given rise to the filing of the petition, and courts want that behavior to be recent and demonstrated. They shouldn't be basing it on projection and anticipation of events or on behavior that happened a really long time ago. If the court decides that a guardianship is needed, it'll appoint a guardian and specify which decision-making powers the guardian will have. We're working with the courts, both the Office of Public Guardian and the Disability Law Project are working with courts to have them understand that guardianship is a significant curtailment of individual rights and other options should be considered. And I think the courts are hearing that and are open to considering alternatives to guardianship. So this is good, and we are seeing more limited orders like Jackie was referring to that are limited either in scope or in the length of the guardianship, or requiring that the court reconsider the guardianship in some specified period of time.
And this is Jackie. We will be providing the courts with a handouts intended for students and their families, so that if someone approaches the court regarding guardianship, the courts are in a good position, or will be in a good position, to help people consider supported decision-making and other alternatives.
Thank you. So I'm just going to talk a little bit about guardianship responsibilities, and then Jackie's going to take over again and talk about alternatives to guardianship. So once appointed, a guardian must exercise their guardianship powers in a way that is least restrictive, the personal freedom of the person under guardianship, consistent with the needs for supervision. They're required to encourage the person under guardianship to participate in decisions, act in their own behalf whenever practicable, and help them to regain the capacity to manage their personal affairs, so they may not need a guardian at some point down the road. Guardians are required to respect the wishes and values, beliefs, and preferences of the person under guardianship, and they have to file annual reports with the appointing court. And if they don't file those reports, they're at risk of getting terminated as guardian.
And another thing to point out about the probate guardianships, the guardian must inform the court if the person under guardianship moves. And if the person under guardianship is being moved to a more restrictive setting, the guardian must get permission from the court to make that move before it happens. And there are some medical issues that the guardian must also go back to probate court to get permission to enact.
Right. I think that the courts give out some sort of direction to guardians when they're appointed, indicating their responsibility to report or get permission for certain things. I hope, anyway.
Okay. So as we've said a few times, in Vermont, people under guardianship retain many of their rights. And this is sometimes surprising to folks, but people have the right to vote, and they have the right to visit with persons of their choosing. And this is a right that becomes tricky when you're the guardian and the person that you're guardian for is choosing to hang out with people that you feel are clearly not in their best interest. There isn't an actual ability of the guardian to forbid that. The best that guardians can do is through their relationship with the person and education about smart choices of who to hang out with and spend time with. Also, people under guardianship have the right to have children and to refuse treatment as well. And this includes services, not just medical treatment, but the right to refuse, for instance, adult developmental disability services or mental health services. And Oh, yes, and backing up to the right to have children, there's also the right to get married. I didn't think to include that.
Well, there is a right to get married. However, there's also a part of the, it's in the town clerk's statute in Vermont that says that a town clerk in Vermont has the right to refuse to issue a marriage license to a person under guardianship without the guardianship's consent. And that's a bit of the statute that we've been looking at trying to change for a number of years. And we actually have had cases involving elders where this is an issue, where a guardian has sought to stop somebody from getting married. And I think in all the cases we've had, the relationship has fallen apart before we actually had to force the point.
But. No, there was one where there was an elderly couple that wanted to get married, and the private guardian was not in support. And then that guardianship was transferred to us, and the people did get married.
Oh, congratulations. So the right to get married, we would certainly argue that you have the right to get married under guardianship, but there is a statutory ability to stop it. So we need to do something about that.
Right. So the reasons why people decide to pursue guardianship over another person pretty much come down to fear. Folks are afraid of what will happen if there isn't someone there to protect the person, and worried that the person will make bad decisions. Sometimes schools will push parents to get guardianship because they're concerned that the parents will no longer be able to participate in decisions around the students' educational services. We will talk a little bit more about that later. There are lots of reasons why guardianship should be avoided. Nancy mentioned some of them. The restriction of rights, the fact that this disempowers the individual from making many decisions or feeling like they have autonomy to make decisions. But another reason, which is different, is that guardianship doesn't actually fix everything. And this comes back to the issue that the guardian is not all powerful. And if individuals can make other decisions and then have the ability to carry them out and will continue to do so in direct contradiction to the guardian's advice, guardianship becomes highly ineffective in those circumstances. So then you end up as a guardian of someone who is putting themselves at risk and making other decisions, and you're essentially powerless to assist them because they just will not accept the help. And so before filing or thinking about filing for guardianship, the first question everyone should ask themselves is, will guardianship actually help address this problem for this person? Another issue to consider is that magically the average 18-year-old becomes a decision maker on their 18th birthday. And if we were to really look at every 18-year-old, if every 18-year-old had to be assessed, evaluated to see if they have mastered decision-making skills, I think we would find that a fair percentage of 18-year-olds aren't quite ready yet. But they forge ahead, and they forge ahead because they've had an opportunity to practice and make mistakes along the way. And they will continue to make some mistakes after they're 18, but they've had a history of being able to try out those decisions and get through the little mistakes over time. Whereas kids with developmental disabilities are often not in a position to have the opportunities to practice and make those mistakes, because all of us are trying to focus on, as children, keeping them healthy, making sure their school experiences is positive and productive and getting them to all their appointments. And basically all of our effort is going into supporting them and meeting their needs. And it's hard to step back and think about a careful way to assist children with developmental disabilities to have the opportunity to learn decision-making skills and make mistakes along the way that aren't actually dangerous. Okay, we're finally on to supported decision-making, which is all the rage these days. Everyone's talking about supported decision-making. And that's because it's really cool. It's an alternative to guardianship that allows a person to really stay in control, make their own life decisions, but with the help of a group of people. And that group, that team, is chosen by the person to be a part of their support network and help them make decisions and also to communicate decisions to others. The principles behind supported decision-making are bulleted here, but essentially the person, all adults, should have the right to be their own primary decision makers, including individuals with disabilities. Some people need more help making decisions than others, but all of us need help making decisions. I am making a decision about selling my house. I am not going to make that decision without talking to many important people in my life, as well as my financial advisor, to figure out how is the best way to go about that and what are the implications, because that's not my area of expertise. And so I need to reach out to other people who can help me make sure that I understand all of the facts that I need to think about, that I have weighed them carefully, and then that I am able to carry those out. I rely on other people, as most of us do, for important decisions. There's a handout that's included for everybody regarding supported decision-making. Actually, there's a few of them, I think. One refers to how to make a supported decision-making agreement, and that's for individuals and their families. It's kind of long, but I encourage people to look through it because it will give you a more concrete idea of what we're talking about. You can say supported decision-making over and over again, but until you actually sit down and go through the questionnaire, it's hard to have a clear picture of what that is. We've also included one or two handouts that we worked on as a pilot project, supported decision-making in terms of education, and did we include others? I think there might have been power of attorney for educational decision-making, and consent to authorize advocacy and release of information. So all of those handouts can be utilized as part of a supported decision-making plan. I'm not quite through yet. Back to our bulleted list. We don't really think about how we learn to make decisions, but it is actually a skill that can be learned. It's a skill that can be taught. And the earlier that we start thinking about teaching people good decision-making skills, the better. We often hear where people are given choices and are allowed choices, but making important decisions in one's life is sort of a notch above that. Decision-making skills are also not all or nothing. We can have skills in some areas, but need more help in others. So someone may be able to choose where they want to live from a variety of options, but they may not have the wherewithal to make a decision about what kind of medical treatment to choose in case of serious illness. supported decision-making should be available to everyone, either using it fully or within a guardianship. You can use this philosophy to help the person with their decisions. Adults have the right to fail without risking everything, because we all make mistakes and wrong choices. And so we need to make sure that people have some room to practice decision-making and make some mistakes without losing their rights. If supported decision-making is used effectively, guardianship should be the last resort. Nancy mentioned that on the probate guardianship petition, there's a series of checkbox that you have to go through and indicate that you have looked at all those alternatives and why they aren't going to work. And I look at hundreds of probate petitions a year, and most of the time they're just all checked off and nothing's written, or they're ignored, or there's a very simple explanation at the bottom. So folks really need to take that seriously and consider the alternatives, and it's better to do that well in advance of the 18th birthday so that there's time to work on getting ready to put some of those things in place. And then lastly, we really need to work on supporting people to develop relationships that continue on into adulthood, because when someone's considering using supported decision-making, if there's no one in their social network for them to turn to, it's very hard for them to take advantage of that. And so I think we all need to pay more attention to ensuring that people grow up and leave school with relationships that last. So how do we create a supported decision-making agreement? First, as I mentioned before, early on, we have to start teaching people and empowering them to make important decisions for themselves and to increase their social networks. When teams are ready, when an individual in the team is ready to create a supported decision-making agreement, you have to sit down and sort of do an assessment of where the person's at and where they can independently make decisions and what are the areas that they will need assistance, and who are the best people, or who's the best person to provide that assistance in each area. Oftentimes, in the supported decision-making agreements that I've participated in, there are multiple people, each of whom may be responsible for a discrete area. So, for example, a person might choose their grandmother or their mother or father to help them with medical decisions, but they would prefer that their friend help them choose where to live. So when you have a team, each person on the team that's identified as a supporter may have different areas that they're assisting in. And in addition to having a decision-making agreement, there are some specific measures that we're going to talk about on the next slide that can be incorporated. And many times it's helpful to have a written agreement, or at least a written plan, so that everyone's clear and can remember what was decided about which areas each supporter is going to help the person with. In terms of additional alternatives that can be utilized, there are lots of ways in which people's money can be protected now, with direct deposit and electronic payment. To some extent, joint accounts, although those you have to be careful with, because they can be fraught with exploitation. But in general, people can have their paychecks directly deposited and set up regular payments so that they're not having to worry about keeping up with bills. Another alternative is to use a representative payee who can actually pay those bills for the person and provide the person with spending money and money for other things that they want to buy, but the core bills will be paid. For people that don't have a lot of income, but can utilize a representative payee, it's really not necessary in most cases to have a financial guardian. There just isn't that much money to be managed. And actually, the responsibility of going back to court every year to report on a Social Security disability income is somewhat tedious for that amount of money. So I would recommend that everyone pay, if you're thinking about these issues or guardianship, that you pay attention to strategies to have the person's financial needs met without going through a financial guardianship power. Trusts can be set up for people as well, special needs or Medicaid qualifying trusts. And ABLE accounts are a relatively new feature in Vermont, and more people, I gather, are signing up for them. Even in public guardianship, we have signed up about, I think, 20 people for ABLE accounts. And Nancy, can you give a brief synopsis of what they are?
Yeah, I would also say, I'll give a brief summary, but there's more information on ABLE accounts, I think, available at the Vermont Developmental Disabilities Council website. ABLE accounts allow you to save money that will not save money and not have it count against your Social Security income. So you won't lose some of your Social Security. You can put it aside in this certain accounts. And I don't remember the amounts off the top of my head, but
it's quite large.
It's quite a significant amount of money.
I think it may be $14,000 a year or something. Yeah, it's a large amount.
And it's not just the individual who can put into the ABLE account, but other people can put money into that account. So it's a great way for protecting income and saving some money for things.
Especially large purchases.
Yeah.
And the rules are quite broad about what you can purchase with the money, what the person can purchase. And finally, case management. A good case manager is worth their weight in gold and can really provide a lot of assistance for a person. So someone that needs help with housing and getting their benefits in line and other issues, those things don't necessarily need to be done by a guardian, but the person can be assisted by a case manager instead, or service coordinator. And all of these things can actually be incorporated into the supported decision-making plan.
So we've listed some resources in the last slide, second to last slide. And the Green Mountain Self-Advocates, Jackie mentioned a pilot that we were involved in earlier. And so the Disability Law Project partnered with Green Mountain Self-Advocates and the Vermont Department of Education and the Office of Public Guardian to work on trying to promote supported decision-making and alternatives to guardianship in Vermont. And Green Mountain Self-Advocates has indicated that they are going to host kind of the be the clearinghouse for information in Vermont about supported decision-making. I can't promise right now that everything that they have on their website is up to date because our last meeting was canceled. And so I can't promise that all the information there is available there, but within the next month or so, it should be. So that's probably the best place to go. The Disability Law Project at Vermont Legal Aid has some information. The National Resource Center for Supported Decision-Making has a ton of information. It's a little bit hard to get through it. There's so much. And then the Office of Public Guardian, I think, has more general information about guardianship. So those are some resources. And finally, we've listed just a list of what the handouts associated with this webinar are on the last page. There were a couple things that I was thinking of when Jackie was talking, and one is, and then we'll get to some questions, but the one thing to bear in mind is that there is not one thing that is a supported decision-making agreement. It's more of a philosophy, I think was a word that Jackie used. And, there's not just one way that it can be. It's very individual, and it's really, there's just not one thing. So you need to be creative, and as I think Jackie said, also figure out what the problem is that you're trying to solve, and then figure out if there are other ways to solve it than getting a guardianship. And I think that a lot of this is very aspirational at this point. There's a lot of talk about it. We are struggling to work our way through how this happens. Supported decision-making agreements that we have been involved in take a lot of time. They take a lot of effort, take a lot of time and a lot of people. So don't think that it's going to be really straightforward and simple. But I think that the process is very valuable because it helps people understand the needs of the person they're trying to support and come up with a creative solution for them. So those are just kind of some final thoughts. And then we have some questions.
Yes, we have some questions here. Here's one that I can answer quite easily. How many people in Vermont have a public guardian? And having just been working on the annual report, last fiscal year, we provided public guardianship to 760 people, I believe.
Is that both?
That includes both individuals with developmental disabilities and elders. The larger number are folks with developmental disabilities, and then I think there were around 100 people who were 60 and older. Another question that's on here is, should both parents be guardians, or is it easier if one of the parents is the guardian? There's no set answer to that. I think it depends a lot on how cohesive the parents are in their thinking. And if people are generally in agreement, then that can work out well. If people have strongly divergent opinions about the best way forward, having a joint guardianship can become problematic and create conflict in the guardianship and in the relationship for the family.
So there's a couple questions here that I think I can answer. If a guardianship is awarded and there is no date that it will expire, do you have to repetition or go back to court at some point? The answer is no. As a rule, the guardianship will continue unless somebody moves to stop it for one reason or another. You do have to go back if you want to modify the guardianship powers. So sometimes if you have somebody maybe they have a full guardianship and the guardians work with the person to help them acquire the skills. So for example, they don't need a guardianship in to exercise one of the guardianship powers. You can go back into court and have the guardianship modified. Again, if you want to you can have the guardianship terminated. You would also go back to court if you wanted to change who was going to be the guardian. Anything that changes the original guardianship order, you do have to go back to court and have it modified. And I think people sometimes will get calls from parents who say, can I name who I want, if they're the guardian for their child, can I name who's going to be the guardian for my child after I die? Can I do that in my will? And the answer is no. You can put in your will who your preference would be, but the only entity that can order a guardianship is a court. So you can't change who the guardian is simply by putting it in your will. And there are other, as Jackie mentioned, there are other times when you do need to go back to court to get under probate court guardianship, to go back to court and get permission to either consent to certain medical procedures for the person under guardianship, or if you're moving the person from a lesser restrictive to a more restrictive living spot.
Another question is a person's IQ a criteria that's used in deciding the guardianship petition, that the court uses to decide the guardianship petition? Yes and no. For the Title 18 guardianships, the establishment of a developmental disability diagnosis does include an IQ score. In terms of the Title 14 guardianships, certainly the evaluator will look at past psychological evaluations and incorporate those into their evaluation. But the IQ score in and of itself in a Title 14 evaluation is not as important because really the cognitive disability could be created by any number of things. As Nancy said before, it could be a mental health issue. It could be a temporary health crisis. And so the IQ score is not as relevant. The evaluator should be looking at the person's ability to make decisions, not so much at the results of an IQ test. There's some on the next page.
So one question is, what would a parent need to continue participating in their child's IEP meetings once they turn age 18? So one of the handouts, or two of the handouts that we provided here three of them actually. So there's a power of attorney for education, POA education handout. And that's a legal document that gives the parent the right to basically stand in the shoes of the student and exercise all of the rights that the student has under state and federal law regarding their education. So the power of attorney for education is one method. The other form that's there is a consent and release of consent to release of education. What is it actually called? It's abbreviated there. Consent to authorize advocacy and release of information. And that says that I want my parent to be invited to all the meetings, and I want my parent to have access to all my education documents, and any information about my school program and placement I want to be given to my parent. So those are two alternatives that you can use.
Another question is, who handles the money piece for people who have a public guardian? So under Title 18, as we said before, there's no financial power, and that's the statute for individuals with developmental disabilities. Unfortunately, most of those folks do not actually have very much money to handle. And so their needs can be met quite well by a representative payee. And some individuals actually are handling their own money. We are always working to encourage independence in every area possible. And so some of the folks that are in our guardianship have learned to handle their own money independently. And that's probably an indication that they are on their way out of our guardianship.
Okay. We have a question about, at what age can parents start using the principles of supported decision-making with their child? I think you can start using them as early as possible. I think that this is going to be a long-term process. We're going to be working with the schools to start, as Jackie referenced, that needing to acquire the skills to make decisions. Unfortunately, a lot of our students who are in special education, basically from very early stage, have been told, you're not making decisions. Somebody else is going to make them for you. That's what they learn. And we have to change that. And so we hopefully are going to be working with the schools. As I said, the Agency of Education has been our partner in the pilot project around supported decision making, and I think there's some support there for starting to work with the schools to introduce these concepts very early on and teach kids as early as elementary school that they're going to be responsible for their decisions, and to help them acquire the skills so that they can make good decisions and know how to gather information, know how to evaluate things. So I don't think there's any age that's too early.
Can people contact us with questions? Yes. I'll answer for both Nancy and I. Yes. And we can add a slide with our contact information on it, so that if you would like to ask further questions of either of us, you can do that.
So I'd like to thank everybody for joining our webinar today. I see a couple of requests for the materials have come in as questions, and I will go ahead and email the materials to those who specifically asked for them. But know that all of the handouts and the PowerPoint are going to be saved along with a link to the webinar on our website. And anyone who signed up for this webinar, you're going to get an email that'll send you the link to go to our website and find that information. I'd encourage everybody to visit our website if you've never gone there before. It's vermontfamilynetwork.org. We have tons of resources. You'll see upcoming webinars listed there. And if you'd like to talk with someone at VFM, we're always delighted to talk to anyone who has any kind of questions for us. We're here to help. Our toll-free number is 1-800-800-4005. Thanks very much and have a great day.